morning, everyone. Happy Monday and Happy New Year. I am Kara Williams with Williams Immigration, and this is another Monday morning edition of Beyond the Soundbite, where we talk about everything U.S. immigration. So y'all know I like to jump right on in. So we've had quite a bit happening towards the end of the year. So I've got several things that I want to talk to y'all about today. So the first thing I want to talk to you about is the Department of Labor last year proposed a new rule that was going to essentially look at the way that we or the way that they, I should say, calculated the prevailing wage for various employment-based applications. Essentially, it was going to raise the prevailing wage for many occupations. That went to federal court. It was struck down in federal court, and now the Department of Labor has simply issued a rule. They've published a rule that essentially says that rule from last year is now absolutely no longer in play. So hopefully that is now completely in our rear view mirror. The next thing I wanted to talk about is the I-9 flexibility. So normally, pre-pandemic, when you were filling out an I-9 as an employer and you were making sure that that was completed within 3 business days of hire, you needed to look at your employees' supporting documents in person. So you couldn't look at a copy of them. You had to actually look at them in person. Well, because of the pandemic, ICE has really backed off of requiring in-person completion of the I-9s. We're allowed to do those now virtually. And so they essentially keep on extending that time where we can do remote views of the I-9 and remote completions. So now it has been extended until April 30th of this year. We're not quite sure if they're going to extend it past April 30th, given the most recent strain of the COVID-19 virus, Omicron. So we will see, but as of right now, the ability to review your I-9s remotely has been extended until April 30th of this year, 2022. Another rule that we have that was struck down in federal court was the H1B Lottery rule. That rule looked at, or would have changed, how applications were chosen in the H1B Lottery, and it would have favored those applications and those petitions that had a higher wage offering to the employee. So DHS has now simply followed up that federal court ruling with a official rule that now says they have completely that is now dead in the water and it's not going anywhere. So they have officially withdrawn that proposed rule. Y'all, the next thing I want to talk about are what's happening at our consulates. So we certainly have seen things start to move at USCIS level, although there's still quite a bit of backlog. We are seeing cases getting processed. But in all honesty, if the case is approved and we have an approval notice, and the individual has the approval notice, but they are outside of the United States, it is still very difficult for them to enter the United States and start working if they need a visa to come in. And frankly, 9 times out of 10, they're going to need a visa to come in. So this is why I continue to talk about what is happening at the Department of State, because the Department of State oversees all of our consulates across the world. So I talked to y'all before about the prioritization of cases, and we have been talking about that since last year, and really before that. When the pandemic first hit, the Department of State came in and prioritized the workloads for the consulates when they started to reopen. Now, the Department of State from headquarter level is no longer prioritizing the workload. Each consulate is allowed to now prioritize their own workload, which means that some consulates simply are not processing certain visa categories based on their own sort of formula of who is actually in the office, how long the office can be opened, what sort of other local rules and social distancing and COVID related issues that they need to address in their own local offices, in their own local consulates. So some visa categories are simply not being processed. That is different as you move to looking at different consulates. So just because one visa category is being processed at one consulate doesn't mean that it's automatically going to be processed at a different consulate. So this is, so we're still in a situation where we're dealing with sometimes fairly lengthy backlogs coming from the consulates. So as a result of now the consulates being able to prioritize their own workload, the wait times at the individual consulates is very, very different. So we do try and check what those wait times are, but to be frank, sometimes they're just not as accurate as they have been pre-pandemic. So we're just kind of rolling with the punches, quite frankly. We did get a little bit of good news coming out of Department of State, which is their hiring freeze is over. They've indicated that they will start hiring in this month, January of 2022, our new year. So hopefully that will mean a little bit more movement in applications. But the real world impact of what's currently happening at the consulates with the backlogs, with some application types just simply not being processed at all, are that families are separated. Some employees are stuck overseas, even though they have an approval notice from USCIS that says that their application was approved. Now all they need to do is that final step and is apply for the visa, and some folks cannot apply for the visas at this point. And employers are still having to plan around backlogs and delays, and it's sort of a moving target. And so, we are bobbing and weaving and working around all of that. And on the heels of all of that, Department of State has issued a proposed rule that they now want to increase their processing fees. So we can comment on that proposed rule. Comments are due by February 28th of this year. So we'll see what happens. But right now, we are dealing with a tremendous amount of backlog out of the consulates, and now Department of State has issued a proposed rule that they would like to raise their fees. So I will keep you updated on any possible fee increase and hopefully any sort of break in the backlog with Department of State cases and their processing. So throughout this pandemic, I've been coming to y'all live Monday mornings. We've been talking about individuals that are stuck overseas who may have an approval notice and that, and they're not allowed back into the United States because of, just the pandemic and what's been happening. Well, that being stuck really honestly goes both ways. Throughout this pandemic, there have absolutely been American citizens that have been stuck outside of the United States. Whether it be there was no air travel available, or there were travel bans, and so certain family members of your immediate family perhaps were not, we're going to have an issue coming in, all sorts of reasons. But we do have U.S. citizens that have been stuck outside the United States because their passports expired. And so they were not, you can't, in general, the rule is you need to have a valid passport in order to travel when you're leaving the U.S. as well as coming back in. The U.S. government has realized that they need to allow, provide a mechanism for those folks to get back in, for those United States citizens to return home. So if you have a United States passport that has expired on or after January 1 of 2020, you can use that passport to travel into the U.S. You can use that passport to travel into the U.S. until March 31st of this year. We do not have word whether or not that March 31st date will be extended. So if you are one of the many U.S. citizens that has been stuck overseas, now your passport is expired, and it expired on or after January 1st, 2020, then you have until March 31st of this year to enter the U.S. Now listen, if your passport expired in 2019 or 2018 and you didn't realize and you're living your best life outside the US, that is fine. However, you are going to have to go through the regular channels of getting that passport renewed, which is going to a US consulate and working through their process. Keep in mind, if you have not already tried to do this, their consular services right now are limited. They are not working. No consulate that I know of is working 100% full steam ahead. But if your U.S. passport expired on or after January 1 of 2020, you have until March 31st of 2022 of this year to re-enter using that expired passport. So if you have any questions about that or anything else immigration related, feel free to give my office a call at 954-903-1337. The next topic I want to talk about is a little bit of good news coming out of our consulates overseas. Some individuals who are applying for non-immigrant visas will have or are eligible to have their interviews waived. So that is huge. That should help, fingers crossed, with the backlogs for work authorized for some work authorized visas, so that they can come into the U.S. And work through this current backlog that we're experiencing. So there are two sets of criteria that someone can meet. So I'm going to run through those criteria for you so that you are all in the know. And just so that we're aware, this is at the discretion of the consulate. And so far, it is this discretion can be applied through the end of this year. So it seems like they're not going to piecemeal it for us, every couple of months. It's through the end of this year. So here are the two sets of criteria. The first set is that you have an approval notice from USCIS indicating that your application was approved. I know that you have filed an application with USCIS. They have reviewed it and they have approved it. They have issued you an approval notice. It is only for H1s, H3s, which are training visas, H4s, Ls, O, P, and Q. So it is not for the whole alphabet of visas that we have out there. Again, it is for H1s, H3s, H4s, Ls, Os, Ps, and Qs. You must be applying in your home country or your current country of residence. So this does not apply if you are trying to apply in a third country, which you are not from and which you are not currently living. So please keep that in mind. You must have been previously issued any visa. So if you were issued any visa in any other category, it can be outside of the H, the L, O, P, and Q. You were issued a visa. And frankly, this is part of it because if you were issued a visa, they have already done background checks on you. And so, and if you haven't had any, overstay issues, they already know who you are and you're already in the system. And you've never been refused a visa. And if you were refused a visa, was that refusal overcome? So either you were never refused a visa, or if you were, that reason for refusal was overcome. And there's no current or potential issues that they can see that would make you ineligible. So if you meet all those criteria, the consular officer has the discretion, and again, this is discretion, that is not mandatory. It is up to the consulate. They have the discretion to waive your interview. The second set of criteria, okay? Again, we're going to need an approval notice from USCIS, same visa categories, H1, H3, H4, L, O, P, and Q. Now this time, if you are a national of a visa waiver country, so those are countries that in general, if they're coming over to the United States as visitors, they do not need to go into a consulate and get a visa. they comment on what's called ESTA. So if you are from a visa waiver country, there is no current or potential ineligibility that is seen within your background and within your application, and you have previously traveled to the US using ESTA. So if you meet the second set of criteria, again, it is completely discretionary and up to the consular officer whether or not they will waive your non-immigrant visa application. But hopefully, this will clear some of the employment-based logjam that we are seeing. When Department of State was prioritizing the workload for the consulates, employment-based categories such as H's, L's, O's, and P's were at the bottom of the list. So many of those applications have, in fact, just been sitting. So hopefully this will be a positive effort to get these applications approved, get people moving into the United States and taking up employment for which the USCIS has actually approved the application. So next topic I want to talk to y'all about are the African travel bans that came out probably about 2 months ago now. The White House administration has ended those travel bans. They ended on December 31st. So they ended just a couple of days ago. They were put in place because it was believed that individuals from some of these African nations we were seeing Omicron COVID-19 variant at its very beginning. And so there was a knee-jerk reaction to create a travel ban. That travel ban ended, like I said, December 31st of last year, so just a few days ago. And countries that were impacted by that travel ban were Botswana, Eswatini, Lesotho, Malawi, Mozambique, Namibia, South Africa, and Zimbabwe. So individuals coming from those African nations are no longer under a travel ban. And they can come in just like everyone else. They, of course, will need to show proof of vaccination and a negative COVID-19 test prior to getting on flights. But that is with everyone across the world entering the US. So a little bit of more good news for our first Beyond the Soundbite in January of 2022. We are seeing EADs for healthcare workers. So effective immediately, we are seeing EAD for healthcare workers. We can request expedited processing for them. If the EAD expires in 30 days or less, or unfortunately, it may have already expired given the current backlogs, and we can request expedited backlogs for those EADs that are specifically for healthcare workers. This is not a time, y'all, to get real creative when determining whether or not you are a healthcare worker. We need healthcare workers on our front lines, in our hospitals, in our clinics, in our urgent care centers, who are helping us combat as a community, as a country, as a world, the COVID-19 virus. So given that employment authorization documents are now taking upwards of 10 months, sometimes they're taking a year, the federal government has decided that we need healthcare workers. We need them here immediately. So if you're a healthcare worker and your EAD is about to expire, or unfortunately it has already expired, we can now request an expedite. And we will, of course, need proof that you have a job offer, that you are currently employed as a healthcare worker. So that is a bit of good news for our healthcare workers and keeping them employed. The last thing, or second to last thing that I wanted to talk about with you all today is flexibility to respond to USCIS notices. So honestly, ever since March of last year, Immigration Service has realized that the flow of information, the flow of documents, government offices across the world have been they've been open, they've been not open, they've been open for, part of their normal working day. And it has been very difficult and very challenging for us to get documents for our clients. For instance, birth certificates, divorce decrees, death certificates, potentially criminal records is another one that's sometimes difficult to obtain. And so the Immigration Service has given us, in general, 60 days extra to respond to certain notices. So if we're looking at requests for evidence, we're looking at notice of intent to deny, notice of intent to revoke, those applications, that 60 days, that automatic 60-day extra time is now extended for until March. So if they made the decision between, last year and March, we now have an extra, we now have extra time, and it extends until March 26th of this year. Now, if you have a notice, if you are appealing a decision, they've actually given us an extra 30 days this go round. So we've got 60 days. It used to be 60 days from the date of the decision. Now it is 90 days from the date of the decision. So effectively, they've given us an extra 30 days. So that's good to know. But certainly, we don't have to wait until the very end. If we are able to get that information, we can certainly send it in earlier. But frankly, there have been several of my clients I know where getting documents overseas has certainly been a challenge, and those extra 60 days have been incredibly helpful. So the last thing I want to talk about is towards the end of last year, the U.S. Passport Agency increased the price of applying for all U.S. passports. So whether it is your first-time passport or whether you're renewing a passport, the fee has been raised by $20. So a first-time adult passport is now $165, and the price to renew an adult passport is now $135. So if you are looking to get a new passport, you should see those new passport fees reflected on the website. I don't know if they are reflected in the paper application itself. I don't know if they've had enough time to make that change and push out that paperwork, but just know that the price of a U.S. passport has now been increased. So folks, that is all I have today, January 3rd of 2022. Again, Happy New Year. I'm excited for this year for all of us. If you have any immigration questions, feel free to reach out to me at my office, 954-903-1337. Again, I am Carol Williams with Williams Immigration, and this has been another fabulous Monday morning edition of Beyond the Soundbite. Have a wonderful Monday and a great rest of your week. Bye, everyone.